Good evening and welcome once again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Dean Jose Roy III. Good evening, Dean Roy. This is the last week of the Senate impeachment court before she goes into a break for the Holy Week. Can you tell us now where is it all leading us to based on what happened today?
Thank you very much, Leslie. Thank you for having me again.
You're welcome.
Yes, we've been presenting evidence since the resumption of the proceedings. I have to say that it's been quite hectic for us. You see, we don't have as much lead time as we would like, and as you know, we're being hurried along. No?
Yes.
I think many were hoping that we would be able to end our presentation before the break. But let me just draw your attention to a couple of things. You remember when we took our first break after the prosecution rested, we asked the court to resolve certain issues.
Yes.
One of which was the formal offer of exhibits and our comment thereto. Now, it was essential for us to determine which exhibits would be admitted before we could line up our witnesses. As it turned out, all the exhibits were admitted, and that has led us scrambling for the evidence and the testimony that we need. And as you know, to complicate matters, the Supreme Court also issued a resolution restricting its personnel and the use of some of its documents. Now, it's important to understand that this resolution also impairs our ability to adduce evidence. I think that what is perhaps most complicated is that even if we're just talking about the sal ends and so forth, we are actually being asked to defend the entire financial life of the Chief Justice.
Yes.
So this will mean going through every significant transaction mentioned in the sal end. As you can imagine, that is going to take some time. We have started by addressing issues relating to the real properties. We have been trying to make the presentation cohesive in the sense that we will be talking about real estate properties and then move on to other issues and so forth. We have been trying our best to keep the presentation connected from witness to witness. It has been quite difficult. In fact, for instance, yesterday, we should have had the testimony of the Land Registration Authority yesterday. However, because of the insistence that we do not begin with a witness who might be asked to testify for a long period of time, we had to suddenly change our order of presentation in order to accommodate the court and the prosecution. And that's how we ended up presenting Ben Slim. And then because we presented Ben Slim, the logical thing to do next would be to present the developer who is connected with that transaction. That was Carmina Cruz.
Yes.
Now, because we rushed her to be presented, she came here lacking many of the documents that were required. Now she has to come back. So we were trying to avoid this because we wanted to throw each issue out the window one at a time. First issue, settle that, then out, so forth, so on. But we're still trying to do that, and you know, the only thing that really matters to us at this point is that one, we are able to drive home or drive across a clear picture of the theory of the defense and the evidence that the defense holds. Two, that the senator judges are able to satisfy their curiosity or their inquiry by asking our witnesses or asking us. Three, which we note most importantly, is that we maintain the clean and strong upward trend favoring the acquittal of the Chief Justice. While I'm not a believer in surveys, I have to say that there's a definite, distinct and significant trend favoring the acquittal of the Chief Justice, and we're very happy for that. Be that as it may, the defense is relying on law and evidence. While we are sensitive to public opinion, we are equally aware that at the end of the day, the only votes that will matter are inside the session hall.
Dean Roy, let's go back to a recent, and allow me to ask you this. It was a question which Senator Judge Joker Arroyo asked, both to the defense and to the prosecution. Is a correctable offense an impeachable offense? Because based on Senator Judge Miriam Defensio Santiago's statement, is she asked the prosecution if there was an intent, a dishonest act to declare the properties of Chief Justice, and to the defense if the Chief Justice himself declared his properties or his bank accounts in good faith. What can you say about this?
Well, that is one of the key issues. Is there an impeachable offense charged anywhere? That is precisely why we have been trying to adduce evidence about the complaint itself. That is precisely why we have been trying to establish that the complaint was politically motivated, not as the result of knowledge of the commission of offenses, but that there is a political instigation of the complaint against the Chief Justice, because that is exactly in line with our theory that there is no real offense, and that anything that we are being told about this is not quite right, this is wrong, or this is not how it should be, has really not been established to be the case.
Yes.
It is becoming clearer as the days pass from the statements of the judges themselves, and even from stories being reported by the media. There does not appear to be any single way to properly fill out an SALN. I think there was a recent investigation or examination conducted, and only 2 of the senators passed the SALN. So, which only goes to show that it's one of 2 things. Either the 21 are all crooks, which I don't think so.
Yes.
Or the instructions or the forms are so vague, so defective, or the law itself is so unclear that there can really be no attribution of malice, fault, or bad faith, and certainly very difficult to attribute or to impute the commission of a crime or an impeachable offense. Now, with that as a backdrop, and your question, what about the opportunity to correct a mistake, it becomes even less likely that this entire proceeding should result in an impeachment. I think that the most intelligent outcome here is a thorough examination of the SALN, the entire procedure, the evidentiary weight of the SALN, and so forth. If our 188 congressmen had devoted their energy to that, we would probably be standing on the sidelines applauding them, instead of taking center floor, taunting them to come forward with what they know.
Dean Roy, let's move to a term that we often heard today, deemed acceptance. What is that? What does
deemed
it mean?
acceptance is simply a declaration by the seller, who considers that the unit has been accepted. When they say that there is a deemed acceptance, there is in fact an implicit recognition that there has been no voluntary acceptance. Now, because if there has been a voluntary acceptance, there is no need to declare that the item was deemed accepted. That is a statement of the seller, not the buyer.
Okay. But earlier I heard you say, you mentioned something about a condo unit not yet being built.
Yes.
Not yet, it had not come yet into existence.
Yes.
Yes. What is the technical factor here? Why is there?
Well, there is a divide in the argumentation. The senators were saying, well, but if you have already put out the money, then that's already an asset.
Yes.
From an accounting standpoint, that is correct.
From an accounting standpoint.
Yes, that is an accounting standpoint because money has been put out. But from a legal standpoint, what did you acquire? A right? A piece of paper? Now, if you look at the form again, it's unclear.
Yes.
Are we talking about rights or are we talking about real estate assets? See? So, you know, that's what I'm saying. That is right from an account. That's still a, and even if the condominium unit does not come to existence,
Yes.
they were correct. That becomes a receivable. That is correct. That was correct. And in fact, I misspoke and said it was a liability. No, it is a receivable. But again, that is an accounting entry. It does not make it legally wrong if you say, well, I don't have the asset yet. Why? Because as far as I'm concerned, when I put out that money, I bought a condominium, nothing else.
Thank you for joining us once again with the Defense Chronicles. This is Leslie Bocobo.